1. U.S. judge blocks Trump's immigration arrests amid legal challenge. 2. Federal judge blocks ICE immigration raids in California, TRO fallout, and constitutional debate. 3. Breaking news. Court blocks indiscriminate immigration stops in California. 4. Federal judge halts indiscriminate immigration raids in LA. 5. Federal judge halts immigration raids without probable cause in California. 1. U.S. judge blocks Trump's immigration arrests amid legal challenge. In a bold move, a California-based federal judge has issued a temporary restraining order against the Trump administration, prohibiting the indiscriminate detention of individuals suspected of residing in the U.S. without legal status. This order also safeguards the right of detainees to legal representation, a critical component often overlooked in previous cases. 3 immigrants, apprehended at a Pasadena bus stop while job hunting, along with 2 U.S. citizens who were mistakenly detained, one reportedly showing identification, filed the lawsuit that led to this decision. In response, the Department of Homeland Security took to social media to criticize the judge's ruling, asserting that it undermines the will of the American people. U.S. District Judge Ma'am Frimpong's emergency measures are a temporary solution while the legal battle unfolds. She underscored the mountain of evidence supporting claims that authorities have been conducting roving patrols, a term for randomly arresting individuals without probable cause, which contravenes the U.S. Constitution. The government is forbidden from basing immigration arrests solely on criteria such as race or ethnicity, speaking Spanish or English with an accent, or being present at certain locations like bus stops or car washes, according to Judge Frimpong. This ruling arrives amidst President Donald Trump's escalating efforts to clamp down on illegal immigration, particularly in California, a Democratic stronghold that has long been a thorn in his side. Raids in Los Angeles have sparked widespread demonstrations against immigration enforcement in the area. A recent immigration sweep at a California cannabis farm resulted in violent protests and the arrest of over 200 people, including 10 minors. According to the United Farm Workers, some farm workers suffered critical injuries during the chaotic Ventura County raids. Human rights activists decry the government's alleged illegal discrimination and violation of constitutional rights. Mohammed Tajsar, a senior staff attorney with the ACLU Foundation of Southern California, emphasized that regardless of skin color, language spoken, or workplace, everyone is entitled to constitutional protections against unlawful stops. The government, however, argues that it is focusing on violent criminals as Immigration and Customs Enforcement, ICE, strives to meet a daily target of 3,000 arrests, part of Trump's declared aim to initiate the largest deportation drive in U.S. history. America's courageous law enforcement officers are removing murderers, MS-13 gang members, child abusers, rapists, the absolute worst from California communities, Homeland Security counted on X, in response to the judge's ruling. But here's where it gets controversial. What do you think about the government's priorities in immigration enforcement? Is it justified to prioritize violent criminals over others? Let us know your thoughts in the comments below. 2. Federal judge blocks ICE immigration raids in California, TRO fallout, and constitutional debate. Imagine a federal judge slamming the brakes on immigration enforcement across California. That's exactly what happened Friday night in a landmark decision shaking the foundations of Trump's immigration crackdown. U.S. District Judge Ma'am Frimpong, appointed by President Biden, dropped a 53-page bombshell, a temporary restraining order, TRO, blocking immigration and customs enforcement, ICE, from conducting detention stops unless agents have concrete reasonable suspicion of unlawful presence. This ruling explicitly bars ICE from using race, ethnicity, accents, location, or job type as standalone reasons for suspicion, calling these tactics likely unconstitutional under the Fourth Amendment. But here's where it gets controversial. The judge didn't stop there. ICE must now meticulously document every stop, justify agents' reasoning in writing, develop official reasonable suspicion guidelines, and implement mandatory retraining. This all stems from a case that started with just 3 detainees in June, but exploded into a massive legal challenge against ICE's California operations. Judge Frimpong tipped her hand during Thursday's hearing, stating, "I think it's important for the court not to burden otherwise lawful law enforcement activities," foreshadowing Friday's sweeping order. Los Angeles Mayor Karen Bass erupted in applause, praising the ruling as a defense of American values and decency against what she called unconstitutional and reckless raids. In a fiery statement, Bass accused federal agents of assaulting Los Angeles. Masked men grab people off the street, chase working people through parking lots, even march through children's summer camps. "We will never accept these outrageous and un-American acts as normal." Now, brace for the explosive claims. Court documents allege ICE agents were indiscriminately targeting people with brown skin at hardware stores, car washes, and farms, sometimes even detaining U.S. citizens by mistake. Plaintiffs argue Trump's team imposed a crushing 3,000 arrest daily quota, pressuring officers to bypass legal safeguards. But here's the heated counterpoint. Trump's Department of Justice vehemently denies any wrongdoing, insisting arrests are legal and arguing the court's restrictions fly in the face of established law. U.S. Attorney Bill Isela fired back, "Our agents will continue to enforce the law and abide by the Constitution." And this is the part most people miss. The ruling also tackles Fifth Amendment violations. After protests forced authorities to abandon a Los Angeles detention facility in June, plaintiffs argued detainees were denied lawyer access. Judge Frimpong reinforced this claim, ordering ICE to guarantee immediate legal representation, a crucial protection often overlooked in immigration debates. So where do you stand? Is this judicial oversight a necessary check on constitutional overreach? Or does it handcuff officers protecting national security? With cities like LA, Santa Monica, Culver City, and West Hollywood joining the lawsuit, and Democrat-led states filing supporting briefs, this battle is far from over. Sound off in the comments. Do you believe racial profiling fueled ICE's operations? Or are these accusations politically charged exaggerations? P.S. The White House stayed silent when Fox News Digital requested comment, an absence that speaks volumes, as this legal earthquake continues unfolding. The TRO remains active while litigation progresses, keeping California at the epicenter of America's immigration firestorm. 3. Breaking news. Court blocks indiscriminate immigration stops in California. In a world where immigration policies are constantly under scrutiny, a recent court decision has brought California's controversial practices to the forefront. A federal judge has put a temporary hold on certain immigration enforcement tactics in several counties across the state, which critics argue have led to racial profiling and severe violations of civil rights. This move has sparked both relief and heated debate, with Governor Gavin Newsom stepping forward to voice his support for the decision. The ruling stems from a lawsuit filed by individuals challenging the constitutionality of these tactics, particularly in Los Angeles, Riverside, San Bernardino, Orange, Ventura, Santa Barbara, and San Luis Obispo counties. The court's intervention means that federal agents can no longer conduct random stops without probable cause, a practice that many believe disproportionately targets Latino communities. But here's where it gets controversial. While some see this as a necessary step toward protecting constitutional rights, others may argue that such decisions hamper efforts to enforce immigration laws effectively. In a statement released by his office, Governor Gavin Newsom praised the court's decision, calling it a triumph for justice and the principles upon which the United States was founded. "Today, we witnessed justice prevail," Newsom remarked on July 11. This ruling puts a temporary stop to actions that violate people's rights and perpetuate racial profiling. His words reflect a broader concern about how these tactics impact families and communities, often leading to unnecessary separations and suffering. Newsom didn't mince words when addressing the root of the issue. He openly criticized policies linked to White House Deputy Chief of Staff for Policy, Stephen Miller, labeling them as driven by chaos, cruelty, and fear. According to Newsom, instead of focusing on dangerous individuals, federal authorities have been detaining Americans and hardworking immigrants indiscriminately, tearing families apart, and subjecting people to harsh detention conditions. All this, he claims, is done to meet unrealistic arrest quotas, disregarding due process, and constitutional protections designed to safeguard everyone against injustice. The lawsuit at the heart of the controversy accuses federal agents of conducting stops without reasonable suspicion, disproportionately targeting Latino neighborhoods, and ignoring fundamental legal principles like due process. As Governor Newsom declared, California stands firmly with the law and the values that our founding fathers envisioned for this nation. He urged the Trump administration to align itself with those same ideals. This temporary block marks a significant development in the ongoing battle over immigration enforcement in sanctuary jurisdictions like California. It raises important questions about balancing national security with individual rights and the role of local governments in shaping immigration policy. And this is the part most people miss. Behind the headlines lies a deeper discussion about fairness, equality, and what it truly means to uphold the Constitution. So, where do you stand? Do you think these measures protect civil liberties, or do they undermine efforts to enforce immigration laws? Share your thoughts in the comments below. We'd love to hear your perspective. 4. Federal judge halts indiscriminate immigration raids in LA. A federal judge has mandated an immediate halt to the indiscriminate immigration raids being conducted in Los Angeles, a decision that has significant implications for the ongoing immigration policies of the Trump administration. On June 8, federal agents and National Guard personnel faced off against protesters outside the federal building in downtown Los Angeles. This confrontation arose from a lawsuit filed by the ACLU, which accused the Trump administration of enforcing immigration policies that have led to the detention of individuals in appalling conditions and denied them access to legal representation. The judge's ruling comes in response to claims that federal agents have been arresting individuals across Southern California without any reasonable suspicion of their immigration status. Since early June, agents from Immigration and Customs Enforcement, ICE, the Border Patrol, and other federal agencies have been conducting operations in Los Angeles and its neighboring counties, apprehending thousands of individuals. Civil rights attorneys have described these actions as an unconstitutional and extraordinary campaign that targets individuals based solely on their skin color. Judge Mam Uzumensa Frimpong, presiding over the U.S. District Court for the Central District of California, stated that there exists a mountain of evidence indicating that arrests are being made based on race, accents, or the nature of individuals' work, which violates the Fourth Amendment's protection against unreasonable searches and seizures. The seizures at issue occurred unlawfully, she asserted. In her ruling, Judge Frimpong issued 2 temporary restraining orders, one that prohibits immigration agents from detaining individuals without reasonable suspicion of their illegal status, and another that mandates immediate access to legal counsel for those arrested. These orders apply to Los Angeles and 6 surrounding counties, and are temporary while the case progresses. However, they could significantly limit the Trump administration's capacity to continue these raids, which have instilled fear in immigrant and Latino communities since they began on June 6. Mark Rosenbaum, a senior attorney with Public Counsel, one of the organizations that filed the lawsuit, hailed the ruling as an extraordinary victory. He emphasized that it represents a complete rejection of the racial profiling tactics and the denial of legal access that have characterized the administration's approach, signaling a return to the rule of law in Los Angeles. In contrast, Tricia McLaughlin, a spokesperson for the Department of Homeland Security, criticized the ruling, claiming that it undermines the will of the American populace. She argued that the actions of federal agents are aimed at removing dangerous criminals from communities, including murderers and gang members, asserting that law and order will prevail. This ruling poses a significant challenge for President Trump as he intensifies his immigration enforcement efforts, particularly in large cities governed by Democrats, whom he accuses of obstructing his mass deportation initiatives. The decision follows closely on the heels of an emergency class action lawsuit filed by Public Counsel, the ACLU, and other groups, which alleges that ICE and Border Patrol agents are engaging in widespread racial profiling, arresting individuals based solely on their appearance or the nature of their work. Since the beginning of June, federal agents have targeted known gathering places for Latino workers, such as car washes and day labor sites, often detaining individuals who appear Latino, regardless of their legal status. Many of these arrests have been captured on video by bystanders and shared on social media. Pedro Vasquez Perdomo, the lead plaintiff in the lawsuit, recounted an incident on June 18 when he and his co-workers were waiting at a bus stop for a ride to a construction job. Armed agents in plain clothes emerged from unmarked vehicles and rushed towards them. Vasquez Perdomo expressed his fear and attempted to flee, but he was apprehended and handcuffed without being asked for identification. He was detained for 3 weeks and is now facing deportation, having never been informed of the reasons for his arrest or any existing warrants against him. He reflected, "I believe I was arrested that day at the bus stop because of my appearance. I was with other workers who all looked Hispanic and were dressed in construction attire." During a recent court hearing, ACLU attorney Mohamed Tajsar argued that the pressure to increase immigration arrests has led agents to overlook legal and constitutional boundaries. To detain someone without a warrant, immigration agents must possess reasonable suspicion that the individual is in the country illegally, a standard that federal courts have ruled cannot be based solely on appearance. Tajsar presented Judge Frimpong with numerous videos of recent raids, media reports, and sworn statements from Vasquez Perdomo and others, asserting that federal agents are detaining individuals based on their Latino appearance, despite lacking any further information about them. They are conducting roving patrols, stopping individuals first and asking questions later, he stated. While they may not admit it, the evidence is clear, they are focusing on race. In response, Sean Skedzielewski, an attorney for the U.S. Justice Department, refuted these claims, stating, "There is no documented evidence that agents are ignoring the law or targeting individuals based on race." He explained that agents are trained to assess the totality of circumstances, which includes various factors such as appearance, location, and the behavior of individuals during encounters. Judge Frimpong expressed skepticism regarding the government's assurances that immigration agents are not engaging in arbitrary stops and arrests. She remarked, "What they should be considering are factors that provide reasonable suspicion that this person lacks legal status, and I am not seeing that." The judge noted that the government could have strengthened its case by providing specific reasons for the arrests of Vasquez Perdomo and other plaintiffs, but it chose not to do so. Other plaintiffs, including U.S. citizens, shared similar experiences of being detained or arrested by aggressive agents before any questions were posed. The future of immigration enforcement tactics in light of the judge's order remains uncertain. Civil rights attorneys have stated that it is the government's responsibility to ensure compliance with the law and the Constitution during immigration operations. However, they also indicated that they would vigorously enforce the judge's order in court if they believe the government fails to adhere to it. 5. Federal judge halts immigration raids without probable cause in California. In a bold move that has sparked intense debate, a federal judge has slammed the brakes on the Trump administration's immigration enforcement tactics in Southern California, ruling that arrests cannot be made without probable cause. But here's where it gets controversial. The judge explicitly banned the use of race, language, or occupation as grounds for detention, a decision that has ignited a fiery discussion about the balance between national security and civil liberties. And this is the part most people miss. The ruling also mandates that federal agencies must now provide clear evidence of reasonable suspicion before making arrests. a shift that could reshape how immigration enforcement operates nationwide. On Friday, U.S. District Judge Mam Uzumensa Frimpong, appointed by former President Joe Biden, issued a scathing order against the Department of Homeland Security, DHS. The ruling came in response to a lawsuit filed by the ACLU of Southern California on behalf of 5 individuals and immigration advocacy groups. They argued that DHS, which oversees Immigration and Customs Enforcement, ICE, had been conducting unconstitutional arrests and denying detainees access to legal counsel. The judge's decision applies to the 7-county jurisdiction of the U.S. Central District of California, including Los Angeles and its surrounding areas. Judge Frimpong didn't hold back in her critique, stating that the Trump administration had failed to provide any credible basis for their arrests. She wrote, "This court decides, based on all the evidence presented, that they are indeed conducting roving patrols without reasonable suspicion and denying access to lawyers." The ruling also extends to the FBI and the Justice Department, which were named as defendants in the lawsuit. Notably, DHS is now required to maintain and regularly submit documentation of arrests to the plaintiff's legal team. During a hearing on Thursday, Judge Frimpong expressed skepticism about the government's claims that arrests were based on intelligence or trend analysis rather than racial profiling. "It's hard for the court to believe you couldn't find one case with a report of why someone was targeted," she remarked, pressing the government to provide concrete evidence of actionable intelligence. In a separate order, she also blocked DHS from denying detainees access to counsel, including visits and calls, at a facility known as B-18, where advocates had raised concerns about inhumane conditions. Immigration advocacy groups have long criticized the treatment of detainees in facilities like B-18, alleging that individuals were held without access to beds, showers, or medical care. DHS spokesperson Tricia McLaughlin fired back at the ruling, stating, "A district judge is undermining the will of the American people." This reaction underscores the deep divide over immigration policy, particularly as President Donald Trump has ramped up enforcement efforts since returning to the White House. Last month, his administration called for ICE to expand deportations in Democratic cities and deployed thousands of National Guard troops to Los Angeles amid protests against immigration raids. California Governor Gavin Newsom, a Democrat, celebrated the ruling on social media, declaring, "California stands with the law and the Constitution, and I call on the Trump administration to do the same." Los Angeles Mayor Karen Bass echoed this sentiment, calling the decision an important step toward restoring safety, security, and defending the rights of all Angelenos. Mohammed Tajsar, a senior attorney for the ACLU of Southern California, emphasized the broader implications. No matter the color of their skin, what language they speak, or where they work, everyone is guaranteed constitutional rights to protect them from unlawful stops. But here's the question that's bound to spark debate. Is this ruling a necessary check on government overreach? Or does it tie the hands of law enforcement too tightly? As the nation grapples with this issue, one thing is clear: the conversation about immigration, race, and justice is far from over. What do you think? Does this ruling strike the right balance, or does it go too far? Let us know in the comments below.